Lukumi is decided in 1993 in a case 3 years earlier called Employment Division against Smith. The Supreme Court rejected a free exercise claim by two Native Americans who had been dismissed from their jobs because they used peyote in a ritual as part of their worship service. And the Supreme Court in that case sort of changed the understanding of free exercise of religion. Prior to that, the case law said that if a law or policy makes it very difficult for somebody to engage in part of their religion, then the government needs to satisfy strict scrutiny, needs to show that it has a compelling interest and that the law is narrowly tailored to advance that interest. In Smith, the court said, well, no, actually, as long as the law doesn't target religion, and this one didn't, Oregon forbade everybody from using peyote, then a so-called neutral law of general applicability doesn't implicate free exercise of religion. The free exercise of religion is essentially an anti-discrimination principle. I wasn't a big fan of the Smith rule at the time. I've since sort of become more ambivalent about it, partly because I thought the rule undervalued minority religions, you see in the Smith case itself. But the part of the case that everybody agreed to is, well, free exercise forbids religious discrimination, and so does the Establishment Clause, by the way. There's a disagreement as to whether it also forbids the application of general laws to people who happen to be engaged in some sort of religious practice, but everybody agrees that it forbids religious discrimination. Now, in recent years, the Supreme Court has entertained what I believe is an extravagant definition of religious discrimination. So during the COVID pandemic, after Amy Coney Barrett joined the court and flipped the majority on this, they struck down a California law that forbade home gatherings of more than 3 households, even though the law said nothing about religion. So if you had 4 households gathering together to watch a football game, the law applied to you. But the court said this is religious discrimination because, well, these people want to have a worship service, but California allows more than 4 unrelated households to gather in a grocery store. And that's just not what discrimination conventionally means. But they have run with this much broader definition of discrimination, and I don't agree with that. However, the law in Lukumi did pretty clearly discriminate. It was aimed at practitioners of Santeria. There was probably a racial element to that, not just religious discrimination, who were engaging in practices that, while I find cruel to animals, are not crueler to the animals than what everybody else was engaging in when they were purchasing meat from the dead bodies of animals slaughtered not for ritual purposes. So I think the case is rightly decided, and it's just a feature of equality provisions that sometimes a law can be unconstitutional because it forbids too little, and not just because it forbids too much. So that the remedy I would want to see is, as we said earlier, for them to ban all animal slaughter, and we're a bit away from that.
It is a problem of, I mean, particularly in this context, but in a lot of contexts, that every argument kind of proves too much. That when we win our argument that this should be banned, we win an argument that we should completely change the way society treats animals. I mean,
Yeah.
really, the same problem came up within the speech case, United States versus Stevens, right?
Yeah,
That
can we come back to that? I just want to put a pin in that for a second
absolutely,
because that
absolutely.
made me think of one of the sort of themes that reemerged throughout the course of the semester, most clearly when we were talking about the Happy case, was the problem for animal rights lawyers of how to offer a court a limiting principle that we don't believe in, right? So, the question arises of, okay, well, if elephants, what about cows? And of course, the other side says that because they want to say it as a slippery slope. And we want to go down that slippery slope, but we know we're not going to win this case if the court goes
Yeah,
down
we'll
that
be
slippery
going down
slope.
that slippery slope all by ourselves, and the court
That's
will
right.
be on the other
Um,
side.
Yeah, and so that's a problem for cause lawyers everywhere. And so, but we talked about that a bit. I should say, Chief Judge Wilson was actually at Cornell about 3 weeks ago. Um, and
Who wrote the dissent
yes, yeah,
in the happy
the
happy
very
case in the New York Court of Appeals?
yeah, and this was not prompted by me, and it was not prompted by somebody in my class. But at one point, the interlocutor, who is a third-year student who invited him, asked him what he was there to talk about, just to give a general talk and answer student questions about legal
Nice.
practice and talk about his career, and he was great. But the student asked him, "What's the favorite case opinion you've written?" And he said his dissent in that case.
Really,
Yeah, he volunteered
really.
that.
You
Uh,
know, I have to say that though I loved his dissent. I loved both of the dissents. I thought they were excellent, but they did both draw a line that I think was inappropriate to draw, and it was really the majority that said, "Well, if we're going to do this for elephants, what about cows?" I mean, and that is totally not a quote. I've read
right,
it a long time ago. I don't remember exactly what she said, but I tend to agree with that. Like you like in order to allow the elephant to win, you have to. I think that Judge Wilson specifically drew a line between wild animals and domesticated animals and talked about how different they are. And of course, no, that's
right.
not a line I'm at all willing to draw. But if you don't draw that line, then every animal on the planet has a right to habeas corpus.
Yeah, no, that's right. And but this is something that um I sort of struggled with when I, 20 some odd years ago, when I did a lot of work with Lambda and the ACLU's LGBT rights project on before we got same-sex marriage, right? Which was asking for additional rights and then saying, but you don't have to recognize marriage. When of course they wanted to recognize marriage, but you wanted to give the court a place to stop.
Right, but you're trying to like give and actually the point where you're splitting hairs actually is not that it's not right. It's not just that you don't like it. It actually doesn't make that much sense. I
Right.
mean,
No,
all of the arguments that would set happy free could be made for a cow. I mean, there's no real
absolutely.
reason that it couldn't. So yeah, it is one of the big problems of practicing law as your method of advocacy for animals. That you're never going to win the whole ball game, and as a result, I feel like stiff. As a result, you have to argue for things that you don't necessarily believe, and I really feel that Stephen Wise, of course, the founder of the Non-Human Rights Project, drew that line really well. He never gave up the farmed animals, but he always was just willing to push them to a side. I think in his heart, what he believed is that you have to break down that wall between animals and humans. That animals have no rights, and then once you do, you can keep going. But that's a really hard rhetorical task to advocate just for the animal that you're representing, and not and try to avoid the implications for anybody else. And
Yeah, I mean,
the
there's it
court can draw those implications, but
right.
you don't want to.
But I also think that there's a relatively simple, although maybe it's, kind of too cute way around that, which is as a lawyer, you have a client, and your job
Yeah,
is to advocate
yeah.
the interests of that client, and that has to be at top of the list, even if it means that other causes that you care about are going to be subordinated,
Yeah.
at least temporarily.